My name is Christopher Lehman, Chairperson of the Commission, and I declare the session to be open. I want to make sure that Ms. Gulea's headset is working properly and set to Romanian. Okay. The Commission is established under Law 252 on the external evaluation of judges and prosecutors. Article 22, paragraph 13 of that law provides that this commission will assess candidates for the Superior Council of Prosecutors Selection and Evaluation Board according to the procedure and criteria regulated by Law Number 26/2022 on measures related to the selection of candidates for the position of members in the self-administration bodies of the prosecutors. The hearing is being conducted under the Commission's rules of procedures for evaluations under Law 26/2022. The subject of today's hearing, Tatiana Gulea, a candidate for the Superior Council of Prosecutors Selection and Evaluation Board. Ms. Gulea, welcome today. I'm joined by my colleagues on the Commission. From my far right, Nadezhda Hryptievsky, to my immediate right, Irmantas Mikilonis, to my far left, Cornel Lebedinsky, and to my immediate left, Saskia de Vries. Our newest commissioner, Virginia Mararu, is not participating in today's hearing. The Commission is also assisted by members of the Secretariat. The hearing is open to the public and to members of the media. The hearing will be conducted in Romanian and in English, and I ask everyone to speak slowly and clearly to facilitate accurate interpretation. The proceedings are being recorded. The recordings of the Commission's public hearings will be available online at the Commission's website, www.vettingmd.org. That will be done within 3 days of the hearing. Ms. Gulea, during the hearing, one or more members of the Commission may ask you questions. Please answer truthfully and completely, and I would note your explanations are important to the Commission in verifying your financial and ethical integrity. In formulating our questions, we will take into account your privacy and, where required and possible, the privacy of family members and close persons. We'll leave out unnecessary details related to bank account information, street addresses, and that sort of information. For your protection and for your privacy, we would ask you to do the same in answering questions. At the end of the hearing, you'll be given an opportunity to make a closing statement. I'll start briefly by reviewing the evaluation process for Ms. Gulea. The Commission initiated its evaluation procedure on the 22nd of December 2023 by notifying you by email and asking you to complete and return the 5-year declaration and the ethics questionnaire. You did return those completed declaration and questionnaire on the 28th of December 2023. As part of the candidate's ethical and financial integrity evaluation, the Commission also obtained information from many other sources, such as the National Integrity Authority and the State Fiscal Service, other public institutions, other financial institutions, and open sources. The Commission assesses the information it obtains from those sources for its relevance and reliability. The Commission sent you 4 rounds of questions on the 25th of April 2024, on the 17th of May, the 22nd of May, and the 27th of May this year, to which you responded in a timely fashion. On the 27th of May, the Commission invited you to attend today's hearing. At that time, we notified you of the specific topics that would be discussed at today's hearing. Ms. Gulea, thank you again for appearing today. I will begin with just a few questions for you, and I would ask you to respond in a complete and truthful manner to the questions. First, I would like to note for the record, if you wish to make any additions or corrections to the answers that you originally provided to the Commission in December or in the other requests for information.
Good morning. I would like to say that I've answered all the questions that were asked by the Commission. I was honest in my answers. I've also attached all the documentation that I had, and everything that I had the possibility to provide, I did provide. And at this moment in time, there's nothing for me to add to the answers that I've already supplied to the Commission.
Thank you. And as a second question, I'd just like to clarify that the answers that were provided in the 5-year declaration and ethics questionnaire in December of 2023, that information is still accurate as of today. Is that correct?
I might have misunderstood the question. Can you please repeat the question?
Are there any changes to the 5-year declaration or the ethics questionnaire that you submitted in December, which is about 5 months ago? Is the information still correct now, or is there anything in those declarations that would have changed since December 28th?
Nothing changed. I continue to support the accuracy of what I've already submitted to the Commission.
Thank you. At this point, I am going to yield the floor to my colleague, Ms. DeVries, for further questioning. No? Who's questioning on this? Cornelis. I'm sorry. I have my notes wrong. Mr. Lebedinsky will be putting further questions for me.
Good morning, Madam Prosecutor Gulea. There were 3 blocks of questions that we're going to raise with you today. And the first one has to do with the complaint of Mr. J. If that'll be required, we can tell you who that person is, but we believe that in the context and also considering our previous communication, I think you do understand who we are going to be talking about. Would like you to tell the Commission, how do you explain the situation regarding the complaint of Mr. J, the action taken against a group of prosecutors, and you were among those prosecutors, and that is still a pending issue and is being looked into by the Office of the Prosecutor General. Thank you for this question. This question was raised with me in the 4th round of questions, and I have answered it in great detail. I have also presented to the Commission all my explanation and all my arguments regarding that complaint that was filed by Mr. J. To my answers, I've also annexed all the relevant documentation, which I believed would make the picture clearer for the Commission. So there were my arguments and what that complaint of Mr. J was about. All I can do now is just to maybe stress certain aspects that I believe to be very important in order to try to bring a little bit more light into this situation. First of all, Mr. G has filed with the Office of the Prosecutor General, he's filed a disagreement with the way in which investigations were being carried out in particular criminal cases and that were initiated on the basis of his complaints. In those criminal cases, he's had, and well, he still is, the injured party. His complaint was examined by the prosecutorial inspection, and at the very outset, they've rejected the allegations and they terminated the procedure against several prosecutors, including myself. And that because they did not establish, in the actions of the prosecutor, they did not establish any disciplinary violations on behalf of the prosecutors. As for the complainant, the petitioner, he disagreed with that solution. So he challenged that with the Disciplinary and Ethics Board. And then that has happened a number of times all over again because the board annulled the solutions of the prosecutorial inspection. And the last time that solution was annulled, and the solution was to terminate the disciplinary proceedings, the Disciplinary and Ethics Board has only addressed some matters related to the procedure. In the decision of the board, given that the circumstances were not laid down that would have contained some indications as to the violations committed by the prosecutors, so that is something to take into account. I would like you to pay attention to the fact that the board has never initiated a disciplinary procedure. That is, it did not initiate a disciplinary procedure for applying disciplinary sanctions. The board would always rule for termination because they found no disciplinary violations committed by the prosecutors. The Disciplinary and Ethics Board has only commented on the fact that the inspector who looked into that report, complaint filed by Mr. J, that inspector did not provide any explanation regarding each prosecutor separately. But that's the intimate conviction of the prosecutor that cannot be determined as regards the prosecutors concerned. Speaking of the merits, when it comes to this complaint of that gentleman and my actions in this regard, I can reiterate that in 2018, Mr. J went to the Office of the Prosecutor General, where he filed a complaint. In that complaint, he expressed his disagreement with the way in which criminal investigations were carried out in several criminal cases. In his opinion, in the opinion of Mr. G, those criminal cases were the investigations in those cases were not being done properly, in his view. And he believed that some illegalities were committed by those who were carrying out the investigation of criminal cases. There was a robbery, that's where the injured party is concerned. A criminal investigation was initiated. During the criminal investigation, there was a criminal case opened with regards to a person. They were disjoined, those criminal cases, and that went to the court for further examination. At the time that he filed a complaint with the Office of the Prosecutor General that I looked at in the unit I was working, at that time that case was already in court. Therefore, given the provisions of the Code of Criminal Procedure, specifically the Article 297, paragraph 4, it provides directly that all of the complaints that are, all of the reports or requests after the case goes to court, then all of them are to be reviewed by the court that is looking at that case on the merits. So these I have already explained to Mr. G. I've laid that down in the answer that I provided to him. I've also shared that answer with the Commission. So this information of legal nature, that is, the provisions of the Code of Criminal Procedure, these were made known to Mr. G, so as for him to be able to tap into this procedural mechanism and to file the complaint properly with the court that is actually looking at or examining that criminal case. In my opinion, such a solution to explain a person the requirements of the law, while my margin of discretion and appreciation being limited as a prosecutor of the General Prosecutor's Office, examining a request of that nature. As for the two other criminal cases that Mr. G referred to in his complaint of 2018, they were still at the criminal investigation stage. There were different criminal investigation actions being undertaken in order to establish all of the circumstances pertaining to the cases that were being investigated. I must mention on this note that carrying out the criminal investigation that is regulated strictly by the law number 3 on the prosecutor service, and this is also regulated by the Criminal Procedure Code. The requirements set up there need to be properly applied. And therefore, the persons that are concerned parties in such procedures, they have the margin of discretion to challenge the actions of people who are investigating cases as set out in Article 299 prime and Article 313 of the Criminal Procedure Code. So there are practically 3 levels where one can challenge the decisions of prosecutors and investigation officers. There is the assigned prosecutor, the senior prosecutor, in this particular case, the chief prosecutor of the Chisinau prosecutor's office, and the investigating magistrate and the Court of Appeal. Considering these provisions of the procedural legislation, I've also put together an answer to Mr. G. And there I've explained how and what should be done, what he can do if he disagreed with the decisions taken by the prosecutors. So I was very specific. I referred to the provisions, the criminal law provisions, and the ones that he can use as a basis for his further actions. And therefore, by that answer, there was no limitation whatsoever to justice. I did not limit his access to justice. Nobody denied him the possibility to supply his arguments to the competent institutions. His rights were not violated, were not infringed. He was not restricted to participate in the legal proceedings where he was the injured party. That answer actually reflects a description of the actions to be taken legally in those particular situations, so what the citizen G could have done. And he was also informed about what he should do should he want to file an appeal directly with the competent bodies. This is in line with the legal framework, and it is within the admissible limits of professional discretion that I have exercised in the context of my professional duties. On this note, I would like to underscore that the allegations against myself only mean that Mr. J has a different opinion about how his complaint should have been addressed once filed with the Office of the Prosecutor General. The complainant did not explain that any of his rights were violated by the answer that I sent to him. He also did not provide any justification, any arguments as to how the information that I explained to him, how that information ended up in harming his procedural position. I have also shared with the Commission a copy of the ruling of the court in a similar case, and there the complaint of the petitioner was rejected. And that is also among the documents that I have attached when I sent my answers to the Prosecutor Vetting Commission. There, the court established that the Office of the Prosecutor General has limited itself only to the examination of the petition and also provided an answer on the basis of the circumstances described by the petitioner, the conditions of Article 5 to 7 of the law on the prosecutor service, and they did so rightly. To conclude, I would like to say that the answer that was challenged by Mr. G, and that answer in relation to which he demanded, he saw that I be imposed disciplinary liability, that was looked into through the lens of the actual facts that he put forward, and that is a legal way, in fact, to settle petitions. This is also within the legal limits when it comes to my professional duties. Concurrently, the explanatory answer that was provided to Mr. G, that was based on the legality test condition, that was also based on the reasoning test, so to speak. And the petitioner was actually duly and properly informed as to the legal order that addresses the conduct of a person, as in what a person has to do when they disagree with how criminal cases are investigated. I acted in line with my professional duties. There is a margin of discretion that I have as well. And thus, I've looked at the matter through the lens of the legal provisions. I've looked into the substance of the complaint from 2018. And I've established the grounds and the facts that were invoked by him. It turned out that the legal sense of those requests that actually had a different, or was supposed to be subject to a different order of addressing it, and that was what I explained to him. This complaint that Mr. J filed was not hidden, was not deleted from the institutional correspondence cycle. It was reviewed by the legal deadline as set out in the procedural law. And as such, the rights of Mr. J, those rights were not limited in any way, were not restricted in any way. An explanatory answer was provided to him, and he's actually did that. He's actually tapped into that possibility. I would also like to inform the Commission that as far as this case is concerned, including as regards myself and other prosecutors who are also concerned parties in this entire disciplinary procedure, a prosecutor for special missions from the Office of the Prosecutor General was among those prosecutors. He was looking into a criminal investigation, and a decision was issued to deny criminal investigation due to the fact that the actions of the prosecutors did not contain the elements of a crime. Mr. G challenged this solution with a hierarchically higher superior, but that request was rejected, and he's gone to court as well. The court rejected the allegations of the petitioner. And the court, as set out in Article 313, there was the investigating magistrate, and the Court of Appeal included all of the documentation related to that complaint, all of the copies of that, of my answers, of the solutions that were adopted by the courts, by the prosecutor for special missions, relevant copies of the documentation of the investigating magistrate. All of these that I just listed, I submitted to the Commission. And I believe that the allegations of Mr. G were unfounded and that they were rightly rejected by the prosecutorial inspection. Thank you. Thank you for your answer. I shall look at my colleagues and see if they have any question to ask. Madam Gulea, greetings. I would only like to follow up to see if I got to the essence of the complaint. So actually, there was a complaint that was filed after the criminal investigation of the robbery was sent to court. Is that correct? The criminal case with regards to the robbery, that was initiated in 2015. And throughout the criminal investigation, the offenders were identified. Given that some of the people who were the perpetrators, the criminal case was focused on those who were not left out of the criminal investigation. And it's particularly those people who were left to be part of the criminal case. The criminal case on them went to court. At the time that the complaint came with the Office of the Prosecutor General, The criminal cases I just referred to were in court already, but there was another criminal case still under criminal investigation. So there were people who were relieved of the criminal case criminal proceeding specifically. So there was some criminal investigation underway at the territorial prosecutor's office. So what the petitioner sought from the office of the Prosecutor General was that complaint was about the cases that were already in court or those that were still under investigation. Well, he was disagreement with regards to all the criminal cases where he was the injured party.
Și respectiv inclusiv cu cauza penală legate a fost alegațiile care a fost
as regards the criminal cases, there were allegations that went to court, and then there were allegations of his with regards to the cases that were still under ongoing criminal investigation. To this day, as far as I know, they did not come to an end yet. As far as I know, the criminal investigation was not completed, and those people concerned there are fugitives. And in the answers that you provided, you've explained in the answers you provided, you told the petitioner what the authorities that he can file complaints with are. Is that correct? Is that what you said, essentially? Yes, that is a correct understanding. I explained him how he can appeal the actions with the chief prosecutor. I told him what chief prosecutor that is that he can apply with, and that is the chief prosecutor of Chisinau prosecutor's office. And I've also told him what are the provisions, the procedural law provisions that he can refer to in order to be able to take such issues up with with the chief prosecutor. Are you aware whether the petitioner went to those authorities the way you told him, and whether those complaints were examined if they were filed? As far as I know, having looked into the documentation materials of the prosecutorial inspection, at the time that 2 years ago, I think he's filed already 70 different complaints and requests with the criminal investigation body, prosecutors who are investigating criminal cases. And just to clarify, because this complaint, the prosecutorial inspection doesn't see grounds for disciplinary liability. The board sends it back. So how can you explain this ping pong that is happening, these complaints being sent back and forth by the board to the inspection? At the very outset of my answer today, I've clarified that the board has only addressed the matter of procedure. I could read out one line from the solution adopted by the board in its reasoning. It says, thus, having analyzed the complaint of the citizen G, the board established that although in that complaint there are the actions of several prosecutors that are at issue, the inspectors did not look into the actions of each of the prosecutors in order to delimit their specific actions and re-verify the conduct that is alleged to be a violation. So they did not look separately into every prosecutor's actions that are alleged to be violations. Practically, they are referring to something that is related to the procedure. And actually, no argumentation whatsoever is provided in order to support the assertions of the petitioner claiming that the prosecutor have committed, allegedly, some disciplinary violations. So the inspection has examined that. Well, currently, this procedure is still underway, the examination is still underway. The prosecutorial inspection is not fully formed currently, and having talked to the chief prosecutor of the prosecutorial inspection, I found out that, well, it was established that until all prosecutors are appointed to this institution, this procedure will stay the same. Thank you. No other questions from me. If there are no other questions from my colleagues, no other clarifications to make, then I'll be moving on to the next question. Madam Prosecutor, what is your opinion regarding the merits and procedure around another complaint from Madam A? There's been allegations that a civil case was illegally withdrawn or taken from the court. Well, this is by you. This is something that I know that the Commission has also asked me about in the third round of questions. And at that time, too, I've answered it. I have also annexed all of the documentation that confirmed that I acted rightly. It is true that a person went to the office of the Prosecutor General, let's say a person X. That person filed a complaint challenging a decision to deny initiating criminal investigation. That decision has been taken by a territorial prosecutor's office. That complaint was assigned to me as a prosecutor working in one of the units. And according to the directives given by the management of that unit of the department where I was working, that case was requested to look into in order to clarify certain aspects related to that complaint filed by person X. As a result of the examination, a draft order was developed on behalf of the Prosecutor General. That case was brought to the attention of the management of the Prosecutor General, and the decision to deny criminal investigation that was taken by the Territorial Prosecutor's Office had been as annulled. And considering that not all of the circumstances were clarified with regards to the case, a decision was made to begin criminal investigation. And the criminal case was sent to the Territorial Prosecutor's Office for that office to carry out investigations. On this case, there already was an examination by the Disciplinary Board of Prosecutors. Can you tell us what the result of that was, the outcome of that was? That complaint has indeed been looked into by the Internal Security Department. That is, before the prosecutor inspection was established, we had that sort of a department at the Office of the Prosecutor General. As a result of that, a solution was delivered. The solution was not to initiate disciplinary proceedings against the prosecutors that the complaint was about, because they found there were no disciplinary violations in their actions. Thank you for your answers. Any other questions, clarifications from you?
Yes, I have questions regarding this civil and criminal case. Could you explain, please, how initiated criminal case influenced the civil court proceedings?
Can you repeat the question, please? Can you please repeat the question?
So my question about civil case. So how initiated criminal case by Prosecutor General Office influenced civil court proceedings? The information regarding initiated criminal case was used in civil proceedings or not, according to your opinion?
By no means did the opening of the criminal case impact the solution or the examination of the civil case in the court. Those criminal proceedings were something that are totally separate from the civil case. And as far as I know, that person was actually won the civil case in court. So the criminal case had no impact whatsoever. At that time, when the criminal investigation was initiated, I mean, that was the case. But what happened afterwards, those circumstances are not known to me.
Do you aware about the final decisions in civil and criminal cases?
As far as I know, the criminal case was sent to court for the court to examine the merits. As for the civil case, I did not keep an eye on the solution. That is not part of my duties, so I don't know what that case ended with.
Thank you for your answers.
Thank you.
Thank you. Now, the last question that I would like to raise with you to clarify certain matters had to do with that loan of 220,000 lei from your acquaintance I. And the question is, did you receive the entire amount in full when the agreement was signed? Or did you receive that amount in installments, the 220,000 amount, I mean, Moldovan lei? That amount, I did not receive that amount on the day that the agreement was signed on. I received it throughout the year 2019 in installments. In item 1.4, that's exactly what it said in the agreement, that by the end of 2019, that person undertook to lend me that amount of money. So I received the money. I have also submitted to the Commission the answers to some questions regarding the reimbursement of the bank loan, and I've indicated the dates and the payments when the amounts were paid. I think that was in April and then in July. And now I can't remember very well, but throughout the entire year until December, I've been given in tranches all this amount of money. It was not all at once, not the entire amount at once. It's just that the agreement was signed on the 3rd of April. Thank you for your answer. There are no other questions from me for this candidate.
I have a question. Could you please explain why the friend who offered this money to you agreed to give this money, and for what period this money was given to you? And if I understood correctly, there was no interest. So why did the friend agree? So first of all, I would like to tell you that in Moldova, friends do not charge interests like banks do. So the same happened in that situation. The person we're talking about is a close friend of mine. We have been friends for about 20 years already. So when I told him that I took a bank loan to buy an apartment for my children that I raised by myself because my husband passed away, so he gave this loan to me without any interest, so that I do not have to pay the interest on the bank loan. So that was the explanation I can give you about these circumstances. So why do we have this question? Because as far as we understood, you first took the bank loan, and only after that you asked your friend, or you just had some discussions. No, I did not ask my friend. We just had some discussions. So in 2017, I took a bank loan, and I repaid the bank loan until 2019, and then the friend found out about my bank loan and the interest that I was paying. So in order not to have to pay the interest anymore, he decided to give this amount of money to me without any interest. So you repaid the bank loan in full. You don't have any debts to the bank. Yes, correctly. And how much do you have to repay to your friend out of the whole amount? By the end of this year, according to the loan agreement, I have the obligation to repay the whole amount because he asked to have the whole amount repaid, but not in installments. So I have another 6 months to accumulate this money. I already made some savings. I have a part of the money ready, so I hope I'll be able to live up to my commitments towards that person who helped me when I needed it. And this money that he gave to you, this 220,000, was it his money or someone else's money? Well, as far as I understood from him, that was his money. Do you have any professional relationships with that person or only friendship relations? No professional relations. We are only friends. So he does not have anything with your professional work. No, we didn't have any cases together. Thank you. I do not have any questions. President, I have finished the list of my questions. Please, the floor is yours.
I'll just confirm there are no other questions from any of the commissioners. You have Saskia.
Am I to understand from your answers that you think that the money that was loaned to you was money of your friend? That it was his own money that he lent to you?
Yes, you have a correct understanding. That's what he told me. It was his money.
And what sort of work does he do?
He is working in a state-owned enterprise. Do you mean his position?
Yes.
He's a driver.
When he offered you the loan, did you ask him, can you afford it?
When we had a discussion with Mr. I, he explained that he received this money from his father. His father had certain bank accounts, so his father sent this money to my friend.
Okay, so the money was from his father.
I did not get the money directly from his father. It is Mr. E, or I received the money from his father. So he had his father's banking accounts, so he could use it. I did not receive the money directly from his father. I received the money from him, from my friend.
Clear. Thank you.
Thank you.
If just confirming there are no other questions. Thank you. Ms. Gulea will give you the opportunity to make a final statement to the Commission.
Esteemed members of the Commission assessing prosecutors, I just want to inform you that for all questions asked by the Commission in all rounds of questions, including in my declaration, in the ethics questionnaire. I provided frank answers. I submitted all of the data that I have. I attached all of the documents. I want to say that during my work, I have never been subjected to disciplinary liability. I work in line with the law, in line with the Prosecutors' Code of Ethics, and I have been encouraged several times by the management. I have a medal for impeccable work. I was also encouraged by the management of the country. I have the Glory of the Work Order. I am sure that you will evaluate my answers, all of the statements I made. Thank you very much for that.
Thank you. And we thank you for your participation in the evaluation process and at the hearing. The Commission will now deliberate on this matter and issue a decision as soon as possible. So the hearing is closed. Thank you.
Mulțumesc. La revedere.